Howdy, everybody. My name is Brian Foley. I'm the managing partner at Houston Criminal Defense Attorneys, PLLC. And today we're going to go over the Penal Code Chapter 22. We're probably not going to go over the whole chapter. We're just going to go over assault, but show you all the different permutations there are. A lot of people get charged with what's called assault family member, and you're going to see that there's actually no specific code section for a family member. It's just sort of a way that they classified here. So let's get into it. Section 22.01 is the section for assault. It's under Chapter 22 of the Penal Code, which covers all the assaultive offenses. And it says, a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse. Now, this section here, including the person's spouse, is sort of a relic from a time when you couldn't actually get charged with hitting your wife, hitting your husband. And so, they have this part. It says it includes the person's spouse. So you can actually get charged for hitting your spouse. Who'd have thought? Seems like a crazy thing to have in the law, but it's there. So that's the first way. That's causing bodily injury. And we'll talk about what that is in a little bit. There's also intentionally or knowingly threatens another with imminent bodily injury, including the person's spouse, or intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative. So we've got bodily injury, we've got threats, and we've got offensive contact. Okay. So the next section here is Part B. It says an offense under this subsection A1 is a Class A misdemeanor, except that it's a felony of the third degree if the offense is committed against a person the actor knows is a public servant while the public servant is lawfully discharging an official duty, or in retaliation or on account of the exercise of official power or performance of an official duty as a public servant. Okay, so that's the first part. It's a Class A under Section A1. A1 is the part that says bodily injury. Okay, bodily injury means any impairment of physical condition or pain. So a scratch is going to be bodily injury because it impairs your physical condition. If you get punched in the stomach and no mark is left, that's pain, probably, right? It's probably painful to get punched in the stomach. I've been punched in the stomach before. It hurt, but it didn't leave a mark. And so that's all going to count as bodily injury. Illness would actually count as well. If somebody gave you an illness some way, that could be an assault. The only time I saw that even try to come up was right when the pandemic started. We were considering, when I was a prosecutor at the DA's office, we were considering charging people with intentionally causing illness in somebody else, or maybe even using it as a deadly weapon. But we pretty quickly stopped doing that. I don't think we actually charged anybody with that, but we thought about what would happen if somebody purposely was coughing on an officer or purposely coughing on somebody in order to give them COVID when we thought it was really, really dangerous. So that's bodily injury. That's under A1. A public servant. So what's a public servant? That is going to be a police officer is actually a peace officer, and we're going to see a different code provision for assaulting a peace officer. But let's say there's somebody inside the jail, like a worker inside the jail. That is going to be a public servant. I think probably like court staff would be a public servant. A prosecutor is a public servant. I think a fireman during the course of that. That's another section where it talks about emergency personnel. But most of the time when we see a public servant case, we are looking at jailers, people who work inside the jail, maybe a nurse inside the jail, something like that. Okay. So then the next section there talks about family violence. It basically says there is no provision for family violence assault, right? There's just this enhancement provision for the punishment range for a bodily injury case. So it says an offense that involves bodily injury is a third degree if it is committed against a person whose relationship or association with the defendant is described by Section 71021, 003, and 005 of the Family Code. Okay, so let's take a look at those, and that'll explain what family violence is. So 0021 is what we call dating violence. Dating violence means an act other than a defensive measure to protect oneself by an actor. It's committed against a victim or an applicant for a protective order with someone who the actor has or has had a dating relationship, or because the victim or applicant's marriage to or dating relationship with an individual with whom the actor is or has been in a dating relationship or marriage. Okay, so basically it means dating violence, and that is somebody you have had some intimate relationship with. If it's a one-night stand, that probably doesn't count. If it's like a 3-night stand, that probably counts. Okay. The next provision is 71.003, family. It means people who are related by consanguinity or affinity, and that means by blood or marriage. And that is determined through a couple different family code sections. So it's not like really, really distant cousins, not anybody. It's a couple, like your uncle's going to count, your mom, your dad, your grandpa, your kids, your grandkids, those are all going to count as family. Okay. And then by affinity means by marriage, anybody you're married to, that's going to count as family member. All right. And then household. The last one here is household. And household violence. A member of a household is a person, even somebody who previously lived in the household, but it means a unit composed of persons living together in the same dwelling without regard to whether they are related to each other. So college roommates, can you commit an assault family member case against your college roommate? Absolutely, you can. And that is going to be the 71.005 household member. Okay. So if it's shown on the trial of a defendant who has previously been convicted of an offense under this chapter, meaning chapter 22, or chapter 19, which is homicide, or section 20.03, 20.04, 21.11, and 25.11. All these different offenses. If you have a prior conviction for one of these different offenses, and it was against a family member or dating relationship member or household member, and your new offense is any kind of assault or things like that. If your prior conviction is for kidnapping or aggravated kidnapping or indecency with a child or continuous violence against the family, okay, then in that case, your new offense is going to be a third-degree felony, even if all you did was cause bodily injury. Okay, so that's subsection 2, and then it includes a subsection A there. That's what we just talked about, and then subsection 2B says if you commit the offense intentionally, knowingly, or recklessly by impeding the normal breathing or circulation of the blood, by applying pressure to the person's throat or neck, or by blocking the person's nose or mouth, then that is called an assault impeding breath or strangulation. And if it's against a family member, then that's going to be a third-degree felony as well. So what if you just strangle your boss at work? Well, if you really almost strangled him to death, they're probably going to charge you with aggravated assault. That's another part of this code. But this part here in particular is just referring to family members. So if you punch your boss in the face and then choke him a little bit, well, he's not somebody you're dating. You don't live with him, not a member of your family. That's going to be a Class A misdemeanor unless they believe you use your hands like a deadly weapon. Okay. And so that is the beginning basics right there of the assault statute. And that's how family violence offenses get filed. They are not their own offense. They are a regular assault. And during the judgment period of that case, the judge makes an affirmative finding on the record that there's family violence involved. And that's how you get a family violence conviction in Texas. Thanks for tuning in, and we'll see you next time.